This Honorable Court of Appeals of Tennessee is now in session.
Well, thank you for joining us today by video. We are conducting this video session just like it would be in the trial court. The appellants will have the opportunity to reserve up to 5 minutes if you wish. I assume you've already talked with Mr. Hivner about that. If there's no announcements or questions, let's begin. Would you call the case, Mr. Clerk?
Northwest Line Builders, LLC versus Bear Communications, LLC.
The appellant ready?
Yes, Your Honor.
Okay.
Ben Goldammer, I represent Bear Communications. I've reserved 2 minutes. May it please the court, the very succinct issue presented here today is whether a downstream party on a construction project can be strictly liable for statutory penalties based on an upstream party's failure to escrow retainage. The facts are largely undisputed. This was the Google Fiber project wherein high-speed internet was installed throughout Nashville. Google was the owner of the project, installing fiber optic cable within the right-of-way, entered into a prime contract with a large prime contractor, Bechtel Infrastructure. Within the Google Bechtel contract, no retainage was withheld. Bechtel, the prime contractor, in turn subcontracted to remote contractor Bear Communications, who is my client. Within the Bear subcontract, retainage of 5%, which is the statutory maximum in Tennessee, was withheld from each payment application, but it is undisputed that those funds were not escrowed in a separate interest-bearing escrow account as required by the Prompt Pay Act.
Did Bear's contract with Bechtel make provision for escrowing the funds?
No. Bear, in turn, subcontracted with a second-tier remote contractor, Northwest Line Builder, Mr. Taylor's client. And again, 5% was withheld as the statutory maximum, but was not escrowed. The overall scope of the contract was around $340,000. The contracted scope was completed in the fall, late summer of 2016, and that's when the last of the regular non-retainage payments under that contract were made. By the time suit is then filed, a little less than 3 years later, in April of 2019, Northwest Line Builders retainage had been paid, which was around $17,000, and the only remaining issues implicated in the case were: one, a claim for extra work that was outside the original contracted scope, which has been settled and resolved, and the retainage penalty claim of approximately $315,000. That issue was brought to a head before the court on summary judgment, and the net effect of the court's ruling was an award of approximately $109,000 based on a 1-year look back, citing to the precedent of the recent snake steel case. Turning to our argument, the first touchstone is that this is a penalty statute. The statute calls it a penalty within the statute itself, and there's no question it's a penalty based on the court's construction in snake steel, wherein the Court of Appeals concluded that the statute was a penalty and therefore should be subject to the 1-year penalty statute of limitations. And I point that out at the outset because it's long been established that statutes that are penal in nature are to be strictly construed by the court. And so with that, our first and primary argument is that under Section 103D of the Prompt Pay Act, the upstream withholding of retainage obviates the downstream escrow requirement. It is our position that the statute is clear and that language is built directly into the statute to avoid cases like this. The prime contractor, who in this instance is Bechtel, has an explicit statutory right under subpart 104D of the Prompt Pay Act to information with respect to retainage. That's built in for the prime. That obviously assumes that the owner is going to be withholding retainage, which is somewhat anomalous and is one of the what happened here. But the prime always has the right to know with each and every payment application the financial institution, the account number, and the amount that's been escrowed. The remote contractor here, Bear, has absolutely unequivocally no such right. The court in Snake Steel made that crystal clear when they stated as much. And the reasons, the real reasons why we believe this exception to the Prompt Pay Act exists is because it would be patently unfair to hold a subcontractor, a remote contractor, liable for the acts and omissions of the upstream parties. The remote contractor has no way of knowing whether the account has actually been established, whether the account has actually been funded, whether the account is actually a true escrow account. What happens quite frequently is people don't understand the statute and they go out and they create a depository account where the owner or the prime contractor, whoever is funding the account, goes down to their local bank and sets up a depository account, and they may deposit the retainage, but it's not an escrow account because they can invade the corpus at any time. Something else that happens quite frequently, and is another reason for the statute, is because the owner or the prime contractor can often pledge as security for the project the retainage corpus. And so a lender may, for example, take a security interest in the entire corpus of the retainage. That would be a violation of the statute. That is something that the subcontractor, who is not in the privity arrangement between the owner and the prime, has no way of knowing if that has been done. And so the statute affords the remote contractor an out. The remote contractor is not liable for the sins of the upstream parties because they simply have no access to that information. Second, we'd submit to the court that the statute is unconstitutional and is unconstitutional as applied. And starting with vagueness, under the statute, under the penalty statute in particular, in order to be awarded statutory retainage penalties, you have to be the quote unquote quote unquote owner of the retained funds. So when the trial court makes a determination that it is going to award retainage penalties, it has to first make a determination that the plaintiff is the quote unquote owner of the retained funds. The obvious problem becomes, why isn't Bear the owner of the retained funds? Why is it this remote contractor? Could it be 100 remote contractors? And if it's 100 different remote contractors in the chain of privity on a particular project, who's to say that the penalty shouldn't be divided up amongst them? The Northwest Line Builders argument, as I understand it, is that everybody below Bear in the chain of privity, every single remote, is entitled to make this exact same claim for $300, thereby exponentially increasing the exposure. And so I would submit to the court that given that the trial court in the first instance has to ascertain who is the owner of the retained funds before it can assess the penalty, that portion of the statute is simply void for vagueness, because there is no definition, there is no way to determine who the owner of those retained funds would be. And the state of Tennessee points the court towards the mechanic lien laws codified in 6611-101 to look to the definition of the owner, I would submit to the court that that definition has to do with property owner. It has nothing to do with the phrase quote unquote owner of the retained funds as it is used within the Prompt Pay Act. I would also submit to the court that the penalty statute is unconstitutional as absurd, because it leads to an outcome where a remote contractor is now liable for something that it has absolutely no way of controlling. It has no way of controlling what the parties above it do upstream. And that leads to an absurd result because it is penalized for something that it has no control over, to the tune of what was here $100,000, and Northwest Line Builders is actually seeking $315,000. Third, I would submit to the court, and this has been briefed, that the claim is barred by the statute of limitations. The court in Snake Steel held that the statute, the penalty statute, was subject to a 1-year statute of limitations. It's the specific statute related to penalties. The court did hold that the discovery rule applied. And respectfully, we would submit that the discovery rule should not apply in the context of a penalty statute. And it's for all the reasons we articulated in our briefing, particularly that penalty statutes are not addressed, are not designed to compensate a party for damages. They are just that. They are penalties. And if you look at the cases within the EPA's penalties and other analogous case law, the discovery rule is never applied there. But I acknowledge that there is precedent that goes directly against me, albeit not binding. I would say that case is up at appeal at the Supreme Court. It has been argued, and I know that as of today, there has not yet been a ruling in that case. And so, insofar as the court is going to address the statute of limitations issue, I would ask that component of the ruling, if it's going to be case dispositive, be held in abeyance pending the outcome of the Supreme Court's decision in the Snake Steel case. I believe it was argued probably 3 months ago, if memory serves. In closing, Northwest Line Builders is seeking to create an obligation that does not exist in the statute. And it's going to have widespread implications for everybody below the owner in some circumstances, and the prime in other circumstances. And the massive risk for trade contractors is going to be that they can do one of two things. They can either gamble and risk being strictly liable for hundreds of thousands of dollars in arbitrary penalties based on something that somebody else upstream did, or they can, on every tier in the chain, escrow more money. And by the bottom of the chain, you're going to have 20-25% of the project corpus of funds escrowed. That is just simply not what the statute contemplates. That does not protect subcontractors. It does not protect the retainage, and it produces an absurd result. Thank you, Your Honors.
Thank you. Okay, it's the appellee's turn. Will we have a split argument here, or?
Yes, Your Honor. David Taylor, representing Northwest. I'm splitting my time with General Summons, who's going to address the constitutionality issue. Your Honor, as I mentioned, I represent Northwest Line Builders, and we're asking this court to do 3 things in this appeal. First, to uphold both the trial court and this court's January 2020 decision in Snake Steel, authored by you, Judge Bennett, that the discovery rule does apply to the 1-year statute of limitation for the $300 a day retainage penalty escrow claim. Second, to reverse the trial court's imposition of a judicial cap on Northwest recovery of its $300 a day claim, which cut its statutory award by 1/3. And third, as General Simons will argue, uphold the constitutionality of the $300 a day statute. First, let me first address Mr. Goldhammer's arguments that under 6634-103D, somehow that obviates the requirement that when a party like Bear Communications chooses by contract to withhold retainage from a company like Northwest, and to be clear to the court, there's no requirement under the statute or any case that any company involved in any construction project actually withhold retainage. What the statute and what the courts have said for more than 40 years, including the legislature, is that if you do decide to withhold retainage, it's limited to 5% and subject to the penalties if it's not properly escrowed. Section D of 34103 contains the exception in a situation where if the owner establishes an escrow account with the prime contractor, then the prime contractor who chooses to withhold retainage from a subcontractor, or a subcontractor who chooses to withhold retainage from a subcontractor, is not required to itself establish an escrow account. In this particular case, it's been undisputed that no one downstream did that. Section D specifically talks about and references 6634-104A, which is the statute that says whenever in any contract for the improvement of real property, and if any money is retained, that retained amount shall be deposited in an interest-bearing escrow account. So Bear's interpretation of that statute is not consistent with the Snake Steel decision. It's not consistent with the Beacon 4 or the Avery and Contracting. It's certainly not consistent with the legislature's intent over the last 40 years.
Well, you talk about there's no requirement for the sub here to withhold retainage, but what they end up ultimately having to do then is come out of pocket because the prime is withholding retainage from them. So that, I mean, there's no requirement unless, you want to pony up money that you don't have from your prime, right?
Well, I think the response to that, Your Honor, is that since this is all a matter of contract, Bear certainly have the ability to negotiate with Bechtel that if in fact it is going to be withholding retainage, that Bechtel follow the law and make sure that the retainage is in fact escrowed. In fact, one of the anomalies of this case is, of course, Northwest has its claim against Bear. Bear also has a statutory claim against Bechtel for not properly escrowing its retainage. So that is all a matter of contract. And because Bear chose to withhold retainage from Northwest, that then triggers the statute that says in any contract, Bear had an obligation to escrow. Bear didn't have to withhold $17,000 from Northwest, but it chose to do so. And when it chose to do so, then the escrow mandate kicks in.
Yeah, but I want to make sure I'm clear on your argument about 103, why 103D does not apply. And you're saying it does not apply because Bear did not satisfy, or excuse me, Bechtel did not satisfy 34104A by setting up the escrow account.
What 103, what happened, Your Honor, is that 34104D was actually passed because of the very issue that Mr. Goldhammer addressed, which is, wait a minute, if I'm a prime contractor and I do make my owner withhold retainage, but if I choose to withhold retainage from my subcontractors, wow, does that mean that I have to put 5% more in an account? Section D has the exception that tells a prime and a subcontractor, hey, if an escrow account has been properly set up, it basically says that, in fact, you don't have to set up another account. And so that's the exception. But in this case, Bear chose to, through contract with Bechtel, not to make sure that there was an escrow account set up. Bear chose to, in fact, withhold retainage from Northwest, and therefore that triggered the escrow mandate trigger the $300 a day. And that's what the statute says, is that 104 says for every single day that retainage is not escrowed, that person who withholds retainage, in this case, Bear, in fact, is liable for the $300 a day.
Now, the D talks in terms of withholding retainage. It doesn't say escrowing retainage. Is there any significance to using the word withholding as opposed to escrowing?
I don't believe, Your Honor, because it specifically references 6634-104A, and that is the section that in fact requires, if in any contract retainage is withheld, that it has to be escrowed. Your Honor, I'm not going to get into the issue of the Judge Bennett, your decision applying the discovery rule. I would say as brief that these set of undisputed facts actually present the perfect situation in a large commercial case as to when the discovery rule is an equitable remedy for a subcontractor like a Northwest, especially because, as it's undisputed, the Northwest work was done in 2016. There was a pay clause that says that Northwest doesn't get its retainage until Bear gets paid. In fact, it was determined, as in the case, that Bear frankly misrepresented to Northwest that you're going to get paid, we get paid. Northwest on its own found out that in fact Bear had been paid back at the end of 2017, and it was only until April of 2019 that Northwest hired counsel and found out that the monies were not escrowed. Let me also briefly, because I want to be sure and give General Simon time, on the issue of the monetary award, as Chancellor Perkins said in his memo, the threat of significant civil penalties acts as a deterrent against future violations and advances the legislative purpose of the Prompt Pay Act. The $300 a day statute is very clear. Chancellor Perkins actually did the math. 1,050 days between the first time the Bear withheld retainage until it was paid in April of 2019. He actually did the math, $315,100, but he imposed a one-year cap. And we believe he did so, Judge Bennett, because of misinterpretation of a footnote in Snake Steel, because in Snake Steel, the court sent it back to on remand for the trial court to determine when Snake Steel knew or should have known that the retainage wasn't escrowed. In this particular case, it was undisputed that Northwest didn't know that its retainage was not escrowed until April of 2019. It is undisputed that the monies weren't escrowed.
Okay, thank you. Your time is up.
Okay, thank you, Your Honor.
General Simmons.
Good afternoon. May it please the court. My name is Tim Simons, and I'm with the Tennessee Attorney General's office. Our office represents the state of Tennessee in this appeal, and we intervened at the trial court level for the sole purpose of defending the constitutionality of Tennessee Code Annotated 66-34-104 of the Prompt Pay Act. Before I address the constitutional arguments raised by Bear Communications, I wanted to mention one preliminary matter, and that is that in last year in 2020, the Tennessee legislature amended many provisions of the Prompt Pay Act, including the statute at issue in this case. And those amendments went into effect on July 1 of 2020. So for purposes of this case and this appeal, we're looking at the 2019 version of the statute and the Prompt Pay Act. I just wanted to mention that. We addressed that in a footnote on our brief, but just wanted to clarify that point. Regarding the constitutional challenge asserted by Bear against the statute, they raised three main arguments about that. First is they claim the statute's unconstitutionally vague and ambiguous under the 14th Amendment and or Article 1, Section 8 of the Tennessee Constitution. Secondly, they claim the statute is unconstitutional as written because its enforcement would lead to absurd results as the statute was interpreted by the chancellor. And third, Bear says that the statute is unconstitutional because it allegedly imposes strict criminal liability for noncompliance with the escrow mandates and therefore purportedly lacks a scienter requirement. Contrary to Bear's assertions, the statute is constitutional, and we believe the court should affirm the chancellor's dismissal of the constitutional challenge. As this court is aware, there's a strong presumption in favor of the constitutionality of statutes passed by the General Assembly, and courts must uphold the constitutionality of a statute wherever possible. All presumptions when analyzing a statute should be resolved in favor of its validity as opposed to against its validity. And the burden of proof on constitutional challenges under Tennessee law rests with the party asserting the constitutional challenge. They have the burden of proof and the burden of persuasion. And this applies with even greater force when there is a facial challenge to a statute. And to prevail on a facial challenge, a party must demonstrate that that the statute cannot be constitutionally applied in any circumstance. So consequently, a facial challenge is the most difficult challenge of this genre. I'd like to first address the Bear's argument that the statute is unconstitutionally vague or ambiguous. The standards, the constitutional standards for deciding such an issue are well established in the jurisprudence. A statute is unconstitutionally vague under the 14th Amendment and Article 1, Section 8, when men of ordinary intelligence must necessarily guess as its meaning and differ as to its application. And conversely, a statute would be deemed constitutional under this standard when its language is sufficiently clear to a person of ordinary intelligence to put him or her on notice as to what conduct is prescribed. Also, statutes don't have to be enacted with absolute precision. They just, in order to pass constitutional muster, they simply have to be reasonably, have a reasonable construction and where people know what is prescribed or what is not prescribed. Bear's argument that the statute is unconstitutionally vague is simply without merit. For example, in its brief that it filed with the court, Bear argued that the statute is unconstitutionally vague because, and I quote, "it is impossible from the face of the statute to determine who is the owner of the retained funds under 104, and that the statute provides no guidance on crucial questions." I think as the counsel for Northwest Line Builders has pointed out, one must simply go no further than the statute itself to ascertain who the owner of the retained funds is and who is entitled to receive the $300 penalty under the statute. If you look at 104B, it says that it provides that when retained funds are withheld pursuant to the terms of a construction contract, the funds shall become the sole and separate property of the prime contractor or remote contractor to whom they are owed, and that will be governed by the terms of the construction contract at issue from which the retainage was held. So one has to go no further than looking at the statute itself to ascertain who the owner is and who are the owner of the funds once they are put in an escrow account pursuant to 104. And they're also the ones entitled to receive the 300-day penalty if the statute's not complied with. And this issue about how you construe 103 with 104, clearly the issue, you have the escrow mandate in 104 that says in any construction contract that meets the $500,000 requirements under the statute, if there's going to be retainage that's withheld, it has to be put in an escrow account. The only exception to that is what's been discussed earlier is 103D, which says where somebody higher up in the chain, prime contractor or a subcontractor or an owner who has taken the money that would be earmarked for this subcontractor further down the chain and has set up a escrow account. So that is the only exception that obviates the requirement whenever you retain, withhold and retain money under a construction contract from setting up an escrow account under 104A. So our view is, if you look at the statute and you look at in conjunction with the other provisions of the Prompt Pay Act, taken together, construed together as an act, that the answers to these questions are self-evident and are reasonably ascertainable to a construction contractor. So we think, based on the rules of construction and the rules pertaining to constitutional challenges, these statutes are not unconstitutionally vague or ambiguous. There's another argument they raise, which they say—
Oh, your time is up, so we'll have to.
Thank you.
We'll have to wonder what you were going to say.
Thank you very much.
Thank you, General. Mr. Goldhammer, I believe you have 2 minutes.
Thank you, Your Honor. First, with respect to this question of vagueness and who is the owner of the retained funds, I will say I think Mr. Taylor just made my argument for me. He just argued that I am the owner of the retained funds and I have a cause of action back upstream. And he simultaneously argues he is the owner of the retained funds and he has a cause of action back upstream. And I guess every other remote contractor who is on the privity level with him also has that claim back upstream. That only highlights this question of who is the owner of the funds, who's entitled to make the claim. Second, with respect to 103D, the statute says in the event that an owner or prime contractor withholds retainage, etc. It would have been very easy to say in the event that the owner or prime contractor escrows retainage. And that would be
except that the statute uses the shorthand by cross-referencing 104A. So yeah, I see what you're saying about escrow, but it does cross-reference the statute that requires the escrow.
Your Honor, I think it says that as a modifier or to explain the phrase use or benefit of. And so when it cites to 104A and B, it's simply explaining that the retainage has been withheld for the use and benefit of those parties pursuant to a separate statute. I don't think it's saying that they've been escrowed for those parties' benefits. Third, I'll just say Mr. Taylor made the argument that this is a matter of contract. Parties can choose to withhold or not withhold. That just simply ignores the practical reality of any construction project. But parties don't have the bargaining strength to tell primes and big behemoth subcontractors that they won't agree to retainage. It just is a practical matter. It doesn't work that way. And that's why 103D exists. I see I'm out of time. I thank the court for their time.
Thank you very much to all of you. And we will issue an opinion in due course. Mr. Clerk, would you recess us?
This honorable court is now in recess until 3 p.m.